Yeah, Evan, we're switching to container transport now. It's more faster and efficient.
But wait, you remember that machinery does rust if it's on deck, right?
Yeah, no worries at all. We'll keep your container below deck. Same as always.
All right, well, once it stays below deck, we good.
In a business, a promise can make you money or cost you everything. But here's the real kicker. When does a promise become a legally binding contract, and when is it really just talk? I am your host, Surya Walcott, and along with my team, Garnet Bristol, Arvinda Kamach, Lydia Phillips, Yasan Durant, David Prasad, and Darren Austin, we will enter the business community to test one thing. What do people actually know about legal intention? Before we put the business community to the test, we need to understand what actually makes an agreement legally binding. In contract law, an agreement is generally formed through offer and acceptance. One party makes a proposal and the other agrees to it. However, that alone is not enough. The law requires something much more: an intention to create legal relations.
So we're at Abbey Cosmetics. This is our first stop. Hi, Gandhi. How are you?
Hi, I'm okay.
That's good to hear. My name is Arvinda Kamash, and I'm a first-year law student. Now, I'm just going around asking the public on their opinions about legal intention when it comes to making contracts. So I'm just going to give you a really simple scenario, and you could just give me your opinion on it.
Sure.
So imagine a husband promises his wife $100. Or actually, we're going to pay $100 in Guyana.
That's true.
Let's say $20,000, right? At the end of every month. But the month reaching, she ain't no money. Do you think that she can sue him successfully?
I think that's a bit overboard. I mean, there wasn't no kind of like legal documents signed to refer to, a paper that he have to give me this $20,000 or $100,000 a month. I think she went a bit overboard with the man.
Yeah, definitely.
Yeah.
You're not wrong to say that, because what happened there is a domestic agreement.
True.
And they're a happily married couple, so the law presumes that agreements like that in such settings are not legally binding.
True.
Because, they expect that parties that are so good with each other have a level of trust and
Yeah.
mutuality,
Yeah.
right, to fulfill their end of the bargain. So that's basically what the law says in that scenario.
Okay.
Thank you for having us.
You're welcome.
Hi.
Monkey.
My name is Garnet Bristol. I'm a law student. I'm here to test the public's knowledge on what they think creates a legally binding contract. What's your name?
My name is Sophie.
So, Sophie, if you and your friend were to set up, let's say you guys started this bad monkey business, and y'all had this agreement that y'all would share responsibilities, split the profit and earnings and whatnot, and then randomly your friend just stopped showing up, just like that. Do you think that was a legally binding contract between the two of you guys?
Not really, I would say. But even though we started out together, some might say it's like a legal contract since you guys did agree to terms and started out together. But at the end, he or she did stop in the middle, and then without no notice or anything, didn't inform you or any information and just, leave you on the spot. So I will say not really a legal contract, but like a promise or something like that, or agreement.
I like your answer. So generally, right, the presumption is that when it comes to agreements between friends, the law assumes that they're not trying to carry it to court or to sue anybody. It's just friends helping each other out. But that changes depending on the particular situation that you're in. If the arrangement between friends is serious and they have clear terms laid down and they split roles and whatnot, in that case, it's gonna be legally binding. We have the case of Simpkins versus Pays, whereby a group of friends would have agreed to enter a newspaper writing competition. And they would have agreed that if any of them won, they would split the earnings equally. However, when one of them won, they refused to split the earnings. The court held that it was a legally binding contract. So yeah, when there's clear roles and there's an agreement to split profits and different responsibilities are delegated to each of the parties, in such a situation, it's going to be legally binding.
All right, so hi everyone. We're heading into Massey to interview the manager and ask her one of the questions based on our scenarios that we're doing today. All right, so my name is Lydia Phillips and I'm a first year law student. So I'm going to be asking you a question based on a scenario and I'm hoping that you're going to give me an answer and I'll explain the legal principle to you. What's your name?
Selena. Selena?
Okay, so the scenario is that you guys bring in different products from different suppliers. So let's say that you have a contract with DDL as your supplier and they're bringing in some drinks for you. And the drinks generally have to be carried like below deck, right? And they made a phone call to let you know of this change, that they're going to be bringing in your beers via shipment instead of flying it in like they were doing previously. And upon doing this new form of delivery, your shipment would have gotten lost at sea. So we're now asking you that because this change was made over a phone call, which is informal, do you think that legal action could still be taken, and is it a legally binding contract?
I wouldn't say it's a legally binding contract because it's over the phone. However, I still think that the company should still take accountability, because whether they would have changed the method of transportation, they still should have guidelines in place to protect the items.
All right, so in contract law, generally when two companies have an agreement or a previous agreement in place, even if they do a phone call, which is considered informal, it can still be held as legally binding because they would have already had agreements in place before that this person is the supplier. So even though they changed the method of transportation via an informal phone call, it is still legally binding and it can be held up in court.
I think it's a bit tricky, but as I mentioned before, I still think they should have put guideline in place for the switch that they had to make.
Yes, they should have. All right, well, thank you so much for answering our questions. Have a good day.
Okay, guys, so we're at boardroom now. Hi, good day. So I'm Surya Walcott, and we're law students, and we're testing the public's knowledge on what they know about creating binding contracts. Who am I with?
Okay, I'm Rakesh.
Rakesh. Okay,
Yes, and
Rakesh.
you're at the boardroom bar.
Yes. So, Rakesh, what's your favorite drink to make on the menu?
My favorite, that would be, say, the mudslide.
Mudslide.
All
Okay,
right.
so let's say you made an advertisement that mudslide is your mudslide is the best in the world, and then I came and I tried your mudslide and I was like, okay, it's average, it's not too bad, but I wouldn't say it's the best in the world, right? Do you think that you would be legally binded to that statement?
No.
Okay, why don't you think so?
Everyone is free to their own opinion.
Mm.
Likewise, you might not like it that much, but then you might get a next customer might come and say, oh, wow, that is the best cocktail I ever had. So it just goes both ways.
Okay, so that's very
And then, it's my job to always welcome the customer, make them feel happy. So if I might say, no, that's wrong, the customer might feel offended. So,
Yes, I understand. So in law, we call that statement, we refer to it as a mere puff,
Yeah.
meaning that it's just like an exaggeration or something to, hype customers, so attract customers. So you were correct, it's not legally binding. The courts look at it as just, a way for you to attract customers
Yeah.
and so on. So yes.
Yes, I'm Durant, and I'm presently here with the CEO of First Defense and Security, Mr. McGregor. I'll be putting a scenario to you to see how au fait you are as it pertains to creating legal relations. So, the simple scenario, as a CEO of this company, let's say you have a vast amount of security officers and you approach one of them telling them, if you resign, I'll do you a favor and I'll give you a sum of monies. However, that person opposed their part, they resign. And when they approach you to honor your words and giving them, let's say, one-off salary or some amount of monies, you say to them, no, I'm not paying you that. Do you think any contract was formed at that point in time? But you saying to them that you'll do them a favor in giving them this one-off money forms a legal contract.
Interesting question. So, I do not think that it should be binding. Alright, the operative word I'm using should be binding based on it being a favor. Alright, I do not say that I will do this for you. Alright, it was not a definite word or a definite term that I would have used that this will happen if you do this. I asked you a favor to resign, and if you do so, I may, if that's the right word I'm using, pay you this monies for doing such.
Okay, that's understood. However, when it comes to the court, because you're a corporate organization, when you say that to one of your employees, they would have acted the way in which they acted because of what you said, and the courts look at it objectively. So they will hold you to what you said, regardless of the fact that you used the term favor. And you may be compelled to pay that employee the amount of money that you would have promised them once they resigned.
In conclusion, while many people may understand the basic idea of what makes a contract legally binding, the finer details are often overlooked. We therefore hope that with the knowledge shared, individuals will approach agreements, whether with family, friends, or business associates, with greater awareness, caution, and an appreciation of the legal consequences that may arise. Thank you.